Hey everyone, we're here at the Home Smart Chicago office. I'm here with Mike, who's an attorney in the area, and he's going to answer all the questions that everyone has in regards to the navigating the Chicago, landlord tenant topics and whatnot. So I'm going to introduce Mike here and have him tell you a little bit more about himself, and we'll go from there.
Good morning, everyone. My name is Mike Mazik, and I'm a real estate attorney on the north side of Chicago. I do quite a bit of work in the suburbs. I do some litigation work as well. So some of that includes false disclosures and other issues related to real estate. But part of those issues involve landlord-tenant issues from time to time as well. So there's a big distinction between the city of Chicago and the suburbs. We're going to talk about that a little bit today, particularly the Chicago ordinance, or the landlord-tenant ordinance, as it's called. There's some people here in the room, so I'll answer some questions from time to time from people here in the room. But one of the key issues to keep in mind is that there are a lot of new landlords, and there are landlords who perhaps moved out of condos when they were younger and moved to the suburbs and are now renting those condos out as opposed to selling them. In some cases, there are people who don't have the financial backing or requirements to get a loan, and therefore they're renting out of their property, or they're tenants themselves. So the landlord-tenant ordinance comes up a lot when it comes to listing properties or representing buyers in properties, and there are a lot of components to it. But for those people who are perhaps first-time landlords, or landlords that aren't perhaps up to date on all the requirements of the landlord-tenant ordinance, this is a good way to have a little bit of insight as to where the trends are these days with the landlord-tenant ordinance. So on slide 2, for instance, landlords used to occupy their multi-unit buildings. There used to be a trend where one person occupied one floor and then perhaps rented out one or more of the units in the building. That trend has gone away. Most of the landlords these days are off-site landlords, and as a result, they're subject to the landlord-tenant ordinance itself. And many of these off-site landlords are first-time landlords. So the requirements of the Chicago landlord-tenant ordinance are perhaps some of the most strict requirements for a landlord in the country. They're very punitive. Oftentimes the punishment for not abiding by one of the requirements of the ordinance is double the security deposit. So that's a big hit for a lot of landlords, and we're going to talk about some of the ways to avoid that today. So on the fourth slide here, the City of Chicago Residential Landlord-Tenant Ordinance governs nearly all the rental units in Chicago. The ordinance was created in 1986 to fight slumlording, or mistreatment from landlords towards tenants. And the ordinance, when it first came out, was a valid one, and it was important, and it's still important to this day. However, some of the requirements and some of the landlords are so prohibitive, it's actually causing some landlords to purchase multi-units in the suburbs as opposed to Chicago. You'll oftentimes hear people who are simply afraid to buy commercial property or multi-unit property in Chicago because of the ordinance. And as a result, now there's a little bit of a backlash. There's even movement in city council to change some of the language of the ordinance so that it's less destructive to landlords who are trying to enforce it, but perhaps not meeting all of the requirements, including things like the security deposit. So that's Chicago. There are also other ordinances in other cities. So for instance, Evanston has an ordinance that's comparable to the city of Chicago. And then some cities, municipalities, and villages don't have any landlord-tenant requirements. You simply sign a lease, and there are no village requirements. But there are some exceptions to the ordinance itself. The first being the ordinance applies to, or doesn't apply to, owner-occupied buildings of 6 units or less. So if the owner lives there and it's 6 units or less, the ordinance doesn't apply. That still means that you should provide a lease, and that there are still requirements for the landlords, including not commingling funds. So that's one of the big ones we'll talk about with the security deposit. In Illinois, most ordinances apply to owners of 25 units or more, if you look at the rest of the state, if there are village ordinance or requirements. But there are two key provisions to the ordinance. These are the provisions that make it good or bad depending on what side of the legal argument you are. But first, the prevailing party gets their attorney's fees paid. So if you're successful on a claim under the landlord-tenant ordinance, the losing party has to pay the prevailing party's attorney's fees. So this is called a fee shifting provision. It is sometimes blamed for the reason, or it is the reason for much litigation sometimes, it's argued, because attorneys will take on cases knowing that they're going to win them, because it's usually black and white as to whether you provided a receipt for the security deposit, or gave interest on the security deposit, or charged too excessive a late fee. Those are usually terms you can't argue. Either you did or didn't. And if you didn't, the punishment is very straightforward as well. So many attorneys will take those cases knowing that they're going to be paid. The other key provision to remember is that most of the penalties are double the security deposit. So if you're looking at $1,200 for a security deposit, the punishment is double the security deposit. So for instance, if you don't provide a receipt or an invoice for damages that occurred and the reason that you're taking money away from the security deposit within 45 days of the tenant moving out, your fine is double the security deposit, plus you have to return the security deposit. So it's very punitive, but if you follow the rules, it's okay. There isn't really, as long as the obligations are met, then there isn't an issue. You don't have to worry about it. The key thing is there are a lot of requirements, and it's hard for many landlords to remember all of them. 90% of the time, there isn't an issue. The tenant isn't going to try to find loopholes in the ordinance to try to squeeze a landlord. However, if it becomes contentious in any way, then there will be oftentimes a fight. And many times when I get a client who says, a landlord client, who says, well, I want to keep money for damage to a carpet or something fairly minimal, I'll often say, well, show me the lease. I have a feeling I can find other ways that you violated the lease. Therefore, don't squeeze the tenant on a $125 carpet stain. Perhaps you should just let it go. But those are all things to consider. Every situation is a little bit different. But like we talked about, the security deposit, that's one of the more common ones. Security deposits have gone out of favor a little bit because of this, because of the strict enforcement of the landlord-tenant ordinance. But we're going to talk about what happens when you keep the security deposit and how to avoid issues related to the security deposit. So on slide 9, for instance, it's the most litigated aspect of the ordinance, because from a practical standpoint, the percentage that you have to give of interest on the security deposit is so small that many landlords just don't do it. Sometimes it's change. Sometimes it's 75 cents, 85 cents. But again, the damages are double the security deposit. So, on slide 10, we have a bit of a breakdown, and these are the things that you have to remember with the security deposit. The ordinance requires a receipt. The receipt has to be very specific. It has to have the names of the parties, the date of the receipt that the security deposit was accepted, and a description of the property. Sometimes handwritten receipts or office store receipts don't have space for all of these things. So it's good to have, if you're representing clients who are landlords, it's good to have a nice receipt that has all of this information in it, because this is strict adherence. So if we don't have a receipt and it's not the proper receipt, we're going to get fined for not having the receipt and the attorney's fees to enforce that provision. So now we're talking about a lot of money. Interest has to be paid. Interest has to be paid annually. So if it is a 2-year lease, you still have to pay interest on each year, even if it's a fairly small amount. So the minimum is set by the city comptroller, and it's usually 1 or 2% or so. And it's not a lot of money for most landlords, but it's important to deliver that money, because that, again, the damages are double the security deposit for failure to pay interest on the security deposit. And then the third item to keep in mind is returning the security deposit. It's surprising how often the return of the security deposit takes more than 45 days. The ordinance is very clear: 45 days for the security deposit, unless there's unpaid rent or itemized damages. If there are damages, it has to be itemized. Landlords can't just guess. It has to be clear. You have to hire somebody to go and assess paint damage, carpet damage, things like that. And then provide that invoice to the tenant. Has to be done within 45 days of the tenant moving out. So those are the trickiest ones. Those are not always followed by landlords in Chicago. And as a result, there's this growing trend to avoid security deposits entirely, which is going to take in move-in fees. Move-in fees are somewhat controversial because they often don't relate to the actual cost of moving in. They are sometimes used as a replacement for a security deposit. So in essence, some tenants' rights advocates will argue that the move-in fee is really just the security deposit, but a non-refundable security deposit, which is not really what the intent of the move-in fee was supposed to be. Move-in fees are generally acceptable as long as they relate somehow to the cost of administering the property. So things like credit checks, transferring information, analyzing numerous applicants. So you're looking at a few $100s for a move-in fee as opposed to thousands of dollars. But the move-in fee is considered a valid replacement for a security deposit, and it also avoids some of the accounting issues that we talked about with the security deposit. Those can all be avoided with a move-in fee. I know that's the general trend, and in Chicago, it exists almost entirely because of the litigation related to security deposits and interest related to security deposits. The second item, so security deposits is the most litigated. The second item that gets litigated frequently is late fees. And I'm not a big fan of charging late fees in general. I don't know that they necessarily encourage payment on time. Sometimes it does, sometimes it doesn't, but it has to be calculated correctly. And there's a formula in the landlord-tenant ordinance that calculates the late fees. If it's done incorrectly or if it's excessive, that too is a violation of the ordinance. So the ordinance requires that fees are calculated at $10 per month up to $500, and then for every dollar past $500, it's 5%. So for instance, the example that the city uses all the time is for a $700 monthly rent payment, the maximum late fee is $20. So it's not, numbers wise, it's not really it doesn't make money for a landlord. It's designed to encourage tenants to pay on time, and if used properly, it does that. Sometimes it's used improperly, sometimes it's used to generate money for the landlord, and sometimes it's used improperly in terms of calculating the dollar amount. And once it's excessive, then the landlord can go or the tenant can go and file a claim under the ordinance. So as a result of this, similar to the security deposit, the growing trend is no late fees. I'll have if it's unenforced, then it's not an issue. So sometimes I'll have situations where a landlord will show me the lease and will have an unenforceable or excessive late fee, and I'll indicate to the client we should not charge any late fees. Even in an eviction situation, when you're talking about thousands of dollars that have been built up, I generally advise landlords, we're not going to charge late fees. We're going to charge the amount that they owe for rent, try to collect that if that's what we're looking for. Even in those situations, if the person's having a hard time paying rent, it's more likely that they're not going to be able to pay back a judgment of some sort. So you may be inclined, if you're a landlord, to enter into a negotiation where the tenant vacates by a certain amount of time, and let's forget about the rent that's owed. It may be more expensive to try to collect that money than it is to actually get that money. So the other situation that happens quite a bit is what's called the lockout. So this is the third scenario that you want to avoid as a landlord, and that is somehow denying utilities, services, etc. to a tenant because of unpaid rent. Even though rent is not paid, the landlord is still required to provide heat, water, gas, electricity, all the requirements that are normally upheld. If something breaks, the landlord has to go fix it, even though the tenant isn't paying rent, perhaps. So under no circumstances is a landlord allowed to shut off gas, turn the heat off, evict a tenant, lock a tenant out. There's just no way to do that. The ordinance in the city of Chicago is very firm that you have to go in and go through the eviction process. And the eviction process starts with a 5-day notice if they're not paying rent, or a 10-day notice if there's another breach of lease. You have to serve that on the tenant. And then once you serve that on the tenant, if they don't cure any defects or unpaid rent or anything like that, then you can go and file the eviction on the day after that 5 or 10-day notice expires. So then you can file the eviction. And just sort of a general look at what the eviction process looks like. First, after we've served the 5 or 10-day notice, we now have to serve the complaint on the defendant or the tenant. That sometimes is hard to do. And once the tenant is served with that complaint, we'll have a court-generated court date, that first status date. At that first status date, the defendant may ask for time to hire an attorney or not. They may ask for time to file an answer to the complaint. There are a number of ways that the court process can be delayed. I generally tell landlord clients that it's about a 3 to 5 month process. The court process itself should be resolved within 2 to 3 months. But after that, there's the eviction process itself, where you get an order of possession, you deliver that to the sheriff. And then the sheriff, depending on the backlog of evictions, right now they're a couple months out, and the weather causes usually a stay in the eviction process. So when the weather is this cold, the sheriff doesn't evict tenants. And so when the weather warms back up, there's usually a backlog. This backlog slowly dissipates towards the end of the year, and then it gets cold again, and then the backlog starts again. So one of the things to consider is it worth it going through this eviction process, or am I better off just trying to negotiate to have the tenant vacate the property? Every situation is different, obviously. I'm a big proponent of encouraging the tenant to leave without filing a lawsuit. There are situations where tenants' rights advocates can draw this out a bit, and that's not necessarily a bad thing. Perhaps there's something that the landlord has done that's been unfair. But either way, both parties are now involved in a long litigation process that neither party wants to be in, that people have to pay for. It causes a lot of animosity. If there's a way to work it out where the tenant vacates or stays under new terms, then that's usually a better arrangement than trying to litigate and go through the eviction process. One of the benefits, though, of the eviction process is that now this tenant has some sort of record, or the landlord has some sort of record that they've been in court and that they lost, and that may affect whether this happens again, because now the tenant may have a judgment against them, or the landlord may have a judgment against them, and that's something that you can look up. That's public record. In Cook County, you can look it up on the Cook County Case Search website, and you can find out whether somebody's been doing this for years, and you can perhaps avoid that landlord or tenant. And one more item about lockouts. The 5-day notice is for failure to pay rent. The 10-day notice is for failure or breach of the lease of any kind. So one of the more common situations now that I'm seeing is Airbnb rental, where the tenant is renting out the property and perhaps even profiting, making money. So with Airbnb, there's a growing theory that perhaps when they've rented out the property previously, that this property, there's no cure for it. You can't serve a 10-day notice and say, you can't Airbnb the property moving forward, but you've already done it. You've already made money off of it. So it's a bit of an emerging area of the law. But as of right now, if somebody's conducting Airbnb through their property, you have to provide a 10-day notice to that tenant to say, stop doing that. And then they have 10 days to cure that, to stop renting out on Airbnb, listing the property. If they continue to do that, then you can file for an eviction, breach of lease, and seek damages that way. There are criminal penalties if a landlord simply changes the locks one day and just decides that I don't want to go through that process, I'm going to just kick the tenant out. The criminal penalties are fines of $200 to $500 per day, plus possession of the unit again. So, and then plus 2 months rent as damages. So it's a very punitive situation for a landlord. And as a result, like I said, there are simply a lot more investors that are avoiding Chicago landlord-tenant situations for multi-units even though the rent is better, perhaps the difficulties with tenants sometimes are hard to overcome for an out-of-state landlord. One of the other items that's a little bit, so that's three of the items. The fourth item to avoid is retaliatory conduct, or something to keep in mind. This is sometimes a way that landlords get themselves into trouble because they'll indicate to a tenant that you're having problems and that perhaps you don't agree on something, and now the tenant's going to get punished for perhaps having brought up repairs that are needed at the property. This falls under the retaliatory conduct provision of the landlord-tenant ordinance. It's written very broadly. It includes a number of different types of conduct. Not only just increasing rent, but there are situations where landlords decrease services. There are situations where you can threaten an eviction action even though conduct doesn't justify it. Refusing to renew a lease could be considered retaliatory conduct as well, depending on the facts involved. So, in essence, a tenant has every right to complain or testify in good faith about their tenancy to government agencies, to officials, to the police, to their friends, to the media, community groups, tenant unions, and to the landlord. And if the landlord then retaliates, that's something that's punishable by the landlord-tenant ordinance. And then lastly, the fifth item that we're going to talk about is a fairly new item. It's bed bugs.
Oh.
So, right, nobody wants bed bugs. They're a nuisance. It's a health issue. There's all sorts of things that bed bugs bring up. But one thing that landlords cannot do is simply say, well, you, the tenant, brought the bed bugs in. You go take care of it. It's not, the landlord-tenant ordinance is not set up that way. The ordinance requires that the landlord resolve the bed bug issue. More importantly, now the requirement includes the bed bug pamphlet, which means that the bed bug pamphlet itself must be given to prospective tenants during the disclosure process and lease signing process. That has to be at the beginning. It wasn't a common item, but now it is. In fact, it's required under the ordinance, and the damages for that are $100, or the tenant can terminate the lease. So those are sometimes severe damages, particularly if it's during the winter months or something like that. And that's simply for not providing the pamphlet. In addition to the pamphlet, there's the landlord-tenant ordinance summary, which, again, those are the same penalties if that summary is not provided. But I've seen a few cases recently where an older version of the summary without the bed bug pamphlet provision in it is provided. That's as if you didn't provide the summary. So same remedies apply. So that summary has been updated in 2016. So there is a new summary, and that document itself, if not provided, $100 and or termination of the lease are the damages. So those are really the five items. Another couple of things that come up oftentimes is when can I access the unit? And generally, most leases will have the provision that requires some sort of communication between the landlord and the tenant, and that the landlord can't simply enter the unit unless it's an emergency situation. If the landlord does want to access the unit, has to get permission, and then he or she has to give 2 days notice to do that. So they can't just enter the property, the same day, unless of course the tenant allows it. Building code violations, repairs, things like that, those are all required within 14 days. So there's a 2-week window. If there are building code violations, to have them repaired. If there are building code violations at the property, that has to be disclosed to the tenant. Again, those are fairly minor items that are very costly if not done. And then lastly, as of 2012, the landlord has to change the locks each time. So you can't just give the keys from the last tenant, turn them over. The ordinance requires that the locks are changed every time there's a new tenant. But those are some of the key points. And again, that's just sort of an overview. If there are questions that you have, my contact information is available. And my website is mazeklaw.com, mazeklaw.com. And I can certainly answer any questions that we have here.
We have a couple online questions
Sure.
too as well, and I guess anybody too in the crowd wants
Yeah,
to
sure.
ask any questions.
Well, I have a couple of questions.
Sure.
You said refusing to renew a lease.
Mm-hmm.
If you say to the tenant as a landlord that I'm going to have you rent month to month, isn't that an agreement? It's a new agreement. It's not a lease, but if you want to go month to month instead of putting them in for another year
Yeah.
or two, is that also against the rules?
No, so the key thing, and again, that retaliatory conduct paragraph, it's just one paragraph, but it's written very generally. The key thing that we're looking for is whether you're doing this because they asked for repairs, or you're doing this because the tenant has done something to offend you, like tell the media or someone else about the condition of your unit. So we can't use shorter lease terms or non-renewal of a lease as a weapon as a landlord.
Okay.
It's almost, I mean, you can certainly enter into a month-to-month lease. You can refuse to renew for just about any other reason. If you decide that you want to increase the rent, or you have a valid reason for your non-renewal, then that's all valid. But if you're doing it and it's provable that you're doing it for retaliatory purposes,
Okay.
the ordinance prohibits that. Hard to prove on both sides, you know. It's sometimes hard for a judge to determine whether a landlord is doing this strictly to retaliate or not.
Well,
But it's hard to do, you
that
know.
goes to the other question I have. When the property is for sale,
Mhm.
and you want the tenants to show the unit, whether they have a lease or not. If they have a lease, of course, the new owner, when it sells, has to honor that lease until it's over.
Right.
However, if the tenant refuses to show the unit, or makes it very difficult for that listing agent to go ahead with their contract with the landlord that I'm going to sell your property,
Right.
what are the options that you have regarding that? I mean, we come across that a lot, where they won't let us in.
Yeah, I agree. I've heard it a lot too, where tenants have openly breached the lease. The first thing to consider is what the lease itself says, and usually the lease itself, depending on, you know, if it's a standard lease or one that's been drafted specifically, most leases will have some sort of 30 or 60-day notice to sell clause, which also would describe, you know, a 48-hour notice window to show the unit.
Okay.
However, I regularly see this breached. I regularly see tenants that don't allow for the unit to be viewed or inspected. I can see it from a tenant's perspective, right? You're going to have multiple people coming in. This is your place. Why do I have to deal with this nonsense? There are people, inspectors are going to come in, strangers, prospective buyers, agents. So I understand, you know, where the conflict comes in, because that seller wants to just sell the property. Why is the tenant getting in the way of this? It's a nuisance for the tenant as well. The best thing I can tell you is that if there is a breach of the lease, you can try to enforce it with a 10-day notice. But then, you know, your remedy is what? You're going to evict this tenant now when you're trying to sell the property. So that's, you know, legally, those are the steps you take. From a practical standpoint, you have to have a conversation with the tenant and just say, when can we show the apartment when you're not there, or that when it doesn't cause you a problem. If it's preferred that the tenant is there, so that, you know, the tenant can see that no one's taking anything or anything like that, then that's fine. What you tell us when you would like that to happen.
And Mike, I'll also add in, you know, I've started doing a lot of 3D tours and videos as well, and I'm starting to do that more for property owners and other agents. So, you know, it's something to consider as well if you're a property owner, to, before your tenant takes occupancy, not only to document the condition, but have a 3D walkthrough. So if you do need to show it at any time during the lease, you can send them a link where they can walk through in 3D.
That's good.
And then, you know, if they're truly interested, then you're not having you've kind of narrowed it into, second visits almost. It's like a second showing.
Yeah.
Right.
Yeah, that's a
videos
great-
as well. Power video, just walking through on a video and having not only for documentation purposes, but showing the prospective person the facility.
Yeah, that's great.
To cut down on showing.
Yeah, that is a good idea.
And like you said, it does sort of inventory what's there in terms of condition and things like that, which goes to issues as to whether you're going to keep any money from the security deposit for damages. So yeah, that's a good option. I mean, it's hard because there is that conflict, but the other thing to keep in mind from a real estate standpoint is you don't want an angry tenant.
Oh no, absolutely not.
So even if you're going to force the tenant to do something like this, it's going to cause strife for this transaction perhaps. Now this buyer may be concerned about
I
a
gotta deal with
problematic
them.
so so now we have these multiple layers of concern. So to the best that you can, you want to make sure that the tenant is comfortable with the people who are coming in, and perhaps make it more efficient. Maybe we do showings for a couple hours when the tenant agrees that the tenant's going to vacate for a little while or be gone somewhere, and we're going to limit showings to that time. The alternative, of course, is to go through the legal process, which I just don't think it's practical.
Right.
It's necessary sometimes, and sometimes that's the only way you can sell the property is to get a court order to allow it. But obviously, it's just best to communicate with the tenant. That's a tough situation. That one's sticky.
We have a couple. So one question that came in was, so just wanted to confirm that the Chicago ordinance is is it an and or an or proposition in terms of 6 units, and you have to live. So it applies if you live in the building. So you have to live in the building and also have less than 6 units.
Correct. Okay. Yeah, to be exempt from the landlord-tenant ordinance.
Okay.
Otherwise, the landlord-tenant ordinance applies.
Owner occupied.
Yeah.
And the question, I guess, another question that came in was, what's the best way to show the security deposit? Like how do you show is there a standard template for the receipt that is recommended?
Yeah, so I have a receipt template that I can send you. My email address is Michael MICHAEL at mazeclaw.com, MAZEKLAW.com, or you can call me 773-800-0141. The ordinance itself lays out precisely what's needed, and the summary itself shows it. So I've just created over time a template that I use that has all of these items to fill in, and so we can't leave anything blank, and it has to show the bank that it's going to be deposited in, the address of that bank. Those are all things that are in the ordinance and required, and it's important to follow all of it. I had a situation last year where, or in 2016, where the security deposit, it was attempted to be deposited into an online-only bank, not a physical location. The bank has to have a physical location in Illinois. So those are all, again, perhaps the ordinance is a little bit outdated. 1986 is a long time ago. And although there have been amendments and changes to the ordinance, it's not really current with what occurs in the market today. So for instance, if you are, maybe you had that condo but can't afford it, so now you have another place, but you're renting out that condo, that's not really what the ordinance thought of as a landlord. The ordinance considered people who had multi-units who perhaps didn't take care of the place, didn't take care of the units, charged too much for rent, didn't treat tenants properly. That's really where the ordinance came from. So some of the changes in the ordinance that are being proposed and are being circulated in City Council involve loosening up the punishment. So changing one word, for instance, shall to may. So right now, the judge shall issue penalties in this amount. But changing it to may gives the judge a little bit more leeway. Maybe they tried to pay the interest, the $1.50. Maybe they tried to pay it, but then there was a dispute. And maybe that doesn't necessarily mean that the landlord was trying to be difficult in any way, but maybe the money just didn't get there, or maybe there was a mistake. Maybe the bank that the security deposit was supposed to hold the money, maybe it's a different location, a different branch. So there's a little bit of movement, and spurred in part by real estate associations, but the ordinance is still in place, still in effect. Those are all the rules and obligations of landlords, and so it's important to follow those.
Then another question was more, when was the interest? How do you calculate that interest?
So there, you calculate the annual amount. So it's a one-time payment for the entire security deposit. So if it's 1.5%, it's 1.5% of $1,200, and you give that payment to the tenant annually.
So if they're on a multi-year, you have to give them that payment. You have to disperse that payment within a certain number of days, or
just within 30 days of the annual, the renewal period.
okay, good to know.
Yeah.
Another question that let's see here. Is there a max amount for move-in fees?
It's not. This is an area that's evolving, so it's not settled yet. But there are cases in the circuit court level which suggest that a security deposit amount, or the monthly rental amount, is considered an excessive amount for the move-in fee. So if you charge $1,200 a month, you can't charge $1,200 for a move-in fee.
That just happened to me. I rented something to my client, and the move-in fee was the full rent.
Yeah. See, I mean, it's not fully resolved, but it's my belief that that's an excessive move-in fee. The move-in fee should reflect the administrative costs of having the tenant move in, and it's my belief that that's an excessive move-in fee, because in essence that's just that's a free month, or it's a non-refundable security deposit, which is now what the move-in fee is supposed to be.
So you
could do that. I'm sorry.
Oh no, go ahead.
So if instead of a move-in fee or the security deposit, you can say this is a what did you just say?
Well, I called it a non-refundable security deposit. That's not. You don't want it. That would be invalid also.
Okay.
Because then it's really punitive, and it's not connected to anything. It's just sort of extra money that you're collecting from the tenant.
Okay.
Which, if that's the case, then you're just better off increasing the rent. Spread that out over a course of 12 months, or make it so that it's not sort of a hidden cost. Because likely in your situation, that property was it was advertised and marketed. This was the rent amount, and then somewhere down the road, it was disclosed that you have to pay this move-in fee. And so it's a bit misleading. That person probably thought that the rent was a certain amount. They didn't think that they'd have to pay 13 months of rent for a year.
Yes, it was a surprise, but she still wanted the unit.
Yeah, and sometimes and see, this is a good example where perhaps, a judge may think that would be excessive, but if the parties all agree and everybody's on the same page, then it doesn't matter. It doesn't wind up in a courtroom, and it's never examined closely.
Well, I've also seen where they want first month's rent, security deposit, and last month's rent.
Mm-hmm. Yeah.
So we're talking almost $5,000 sometimes,
right.
Depending on the rent.
Right. Yeah, and I've seen that more and more also.
Yeah.
Is there a limit? And that kind of ties into the next question. Is there one question was the person believes that there's a 2-month limit on security deposit. That's the maximum.
That's correct. Yeah.
And then, but is there a limit on prepaid rent?
Nothing indicated in the ordinance. So the ordinance doesn't indicate any sort of limit on the rent, but it's more of a practical issue. How are you limiting the number of potential occupants by charging that much prepaid rent? In some cases, tenants want to distinguish themselves from other tenants, and even if there isn't a prepaid rent requirement, sometimes tenants will say, I'll just prepay the whole year, or I'll prepay the first 3 months. And that's a way, if there's a competitive rental situation, that some tenants may bring up. It's not the landlord requiring it, but sometimes the tenant will just say, I'll do this. and sometimes that distinguishes that tenant over others.
Does that really, like, as a landlord, from their perspective, like, let's say they charge a prepaid rent amount and something happens during the lease, can they, make a claim towards that prepaid rent? I mean, if they're using that prepaid rent to offset the limitations of the security deposit, you know what I mean? The
Right.
2 month.
I mean, there's probably if you were going to terminate the lease, then the tenant gets prepaid rent back.
Okay, so it's
So
not
they-
really you couldn't make a claim, let's say, towards, let's say the lease terminates mid term and all your appliances removed. You couldn't use that potentially as to
No.
offset any risk in every case.
No, it would literally be just acceptance of rent prior to the month that they're going to occupy.
So that prepaid rent really is only offsetting the risk of payment. Really, that's it,
Right.
not damage or anything to the
Or
facility.
if you
Correct,
have,
yeah.
or if you have like 4 other clients that wanna buy it, that want to rent a place, and you say, well, I'll give you 4 months rent up front.
Right.
Just to, it's like having more than one offer on a property,
Right.
and what are you gonna do to get it?
It's true. Yeah.
Okay.
And it sometimes is encouraging to the landlord that the prospective tenant has reserve funds, that if something happens to their job or whatever,
Right,
that they have this money in advance.
Another question that came in was, from a landlord's perspective, can you, if the move-in fee is limited to, you wanna try to keep it definitely less than the first month,
Yeah.
can you also tie it to pet fees or other fees, you know what I mean?
yeah.
Can you get around that with different fees?
Yeah, I mean, you can, again, it's sort of an evolving area of law right now, so there isn't anything that indicates it in the ordinance as it relates to fees or anything, but I have seen landlords get around it a little bit by using pet fees or cleanup fees or things like that. As long as, again, part of it is just making sure the tenant is aware. I think the issue with a lot of the move-in fees is that it's a bit of a shock for a lot of tenants. And so if it's clear up front, rent is this, there's a move-in fee that covers this, this, and this, that sort of disclosure is wonderful evidence when you're representing a landlord that this tenant knew, this is in the lease, we had this conversation, and that we're not just gouging the tenant. These are all fees connected to something that's actually incurred as a cost of the landlord.
So from an agent perspective, it'd probably be best to put that on the listing or the
Yeah.
agent remarks, or maybe
Yeah.
even if the description is allowed in the MLS listing.
yeah.
Yeah.
That's a good idea, because you've gotta cover yourself too,
Yeah, there's agent liability issues all the time in
Uh-huh.
these types of listings, and
sure.
I've had many situations in court where the tenant or client comes in and says, well, the agent told me this, and perhaps we don't have a written record of this, and it's a little bit harder to prove. But if it's in an MLS sheet that I can show in court, then it's much easier to show that this has all been disclosed. We were upfront about all of this.
So this is a kind of an interesting question.
Yeah.
Since the Chicago ordinance limits you to a 2-month security deposit,
Mhm.
or 2 months of rent, could you structure our lease where it's the first couple months are higher, significantly higher than the tail end of the lease? So let's say
Prorate.
$3,600 a month, and then it goes to $2,300 a month, so you could get whatever your security deposit.
Yeah, I mean, the ordinance itself doesn't require that each month is the same payment amount, so rent can change, and as long as the tenant agrees, you can do that. It sounds a bit predatory. It sounds like
Yeah.
it's a little bit close to what might be problematic if it's in front of a judge, but there's certainly no I mean, we see it all the time with commercial leases where the rent changes regularly throughout the term of the lease, so there's no requirement that the rent has to be the same amount, but that's a little bit too close to where you might just want to have a conversation about, well, what are we actually doing? Are we concerned that something is going to be damaged with this tenant? And if that's the case, we already know it's very hard to get money if something's damaged anyway. So maybe we just keep it a little bit cleaner and above board so that we don't have to explain why we took extra money early in the lease versus later in the lease.
There's a couple more questions. I'll try to wrap
Yeah,
through
sure.
them. Minimum. So there's a the person that had a question about that they understand that there's a heat level you're supposed to provide, or apparently,
Yeah.
but is there a cooling level?
No, I mean there's no cooling level. There's as far as I know, I might have to check if that's been updated or not. But I don't know that I don't believe that there's a cooling level. The last case that I had last year, there was no cooling level. But there's something in every lease called the implied warranty of habitability, which is sort of a catch-all that tenants use and landlords to explain whether a property can't be occupied. So there's this quiet enjoyment provision. There's all this. There are warranties in each lease that suggest I have to be able to use this to live and to sleep and to eat and have my children not at risk and things like that. So if the property is too cold, or I'm sorry, too hot, you might have to address what's happening because there's no cooling requirement. You might have to address what's happening. Did the tenant know, for instance, that there isn't an air conditioner? Or did the air conditioner break and we're just saying we're not going to fix it because it's too expensive? The bigger issue is trying to figure out whether there's is the tenant going to come back and say, I can't occupy this property anymore because it's too hot. And even though the city may say that there isn't a specific requirement for cooling, perhaps there's a habitability or quiet enjoyment issue that we're not going to be able to reach in this lease. And if it is truly too hot, then they can't live there, and they can terminate the lease, and the landlord could be liable under those terms.
Okay. And then one question is like small repairs. Can you make the tenant responsible for small repairs, or
Yeah, so I've seen that in leases where the tenant is responsible for certain repairs. Again, if it's up front, it'd be great if it was clearly designated what those repairs consist of. I don't think there's an issue with the ordinance if that's clear and upfront in the lease. However, it's really hard to specify what repairs are going to be tenant obligations and what repairs are going to be landlord obligations. The lease is very clear that repairs, or the ordinance is very clear that repairs have to be made within 14 days, and if a tenant has minimized some of that, then that's fine. But generally speaking, you can't make a tenant responsible for plumbing and air conditioning and roof repair, window repair.
Yeah.
It's too hard to enforce a provision like that. But minimal repairs, that's probably reasonable as long as the tenant is on board up front and you have some sort of list. It'd be great to list, these are the things if there's something that occurs regularly that the tenant is going to fix, then that's fine. Things like, shoveling snow, for instance. You can write into the lease that the tenant is going to shovel snow from the walkway. And perhaps even the tenant gets some sort of compensation or reduction in rent for that. Those are all things, if outlined properly, then it's not going to be an issue for the landlord because there's evidence that the tenant has taken that on as an obligation. But small repairs is a little bit, if I was representing that client, I would just say small repairs is a little bit too general. We probably have to narrow down what that means, just so that we don't get in trouble down the road.
Got just a couple more
Sure.
questions, and if anybody else chime in as well. Can landlords report to credit?
Yeah, and well, you can. The process for doing that has changed. So as of July 1st last year, Equifax, Experian, and Trans, they all changed their the formula that discloses whether it affects their credit score or not. And so for some lenders, for instance, a judgment for an eviction may not affect your credit score. A dollar judgment would do so, but a judgment for eviction might not. So can a landlord interact directly with those companies? I believe so. I believe that a landlord can send proof of a judgment to credit companies. The best way though for something like that to happen is to record a judgment, either eviction or a judgment for rent owed. So a monetary judgment or an eviction to have that occur fully so that the judgment is valid and enforceable, and then that shows up on credit reports, but more importantly that it shows up on the Cook County case search. I think it's just a good idea for landlords, agents, everybody to put in the defendant's name, the prospective tenant, and just see if they've been sued before in eviction court.
The with renters, the next question kind of goes on renters insurance. Like how is it best to protect, from a landlord's perspective in terms of renters insurance? Can you require it? Is there anything you should put in there to require the renter's insurance be?
Yeah, I mean it's really hard because renter's insurance will sort of cover what's in the unit and the renter's personal belongings, but the policy itself, the landlord policy that you would get, should cover things, like damage to pipes and things that might cause damage to the tenant's personal belongings. So in the lease, you can certainly designate that the tenant is required to carry renter's insurance for their personal belongings.
Are you aware of, this is kind of a more side question that I have is, are any insurance policies cover the cost of evictions or anything like that? Or
I don't believe so. I don't believe so. I mean, you might have an umbrella policy that might
kick in or
so
something.
if you have an umbrella policy, you could probably get it covered, but the landlord policy itself wouldn't cover something like that.
I've got a couple more questions that I wrote down for people. One person put that they heard that the tenants can now take a property tax deduction. Have you heard anything with that?
I'm not familiar with anything like that. No. So that the tenant would.
But there has to be some kind of language in the lease. But
I've never experienced something like that. I mean, it's probably. I suppose it's possible if the tenant is actually paying for some part of the property taxes, which is common in commercial leases, but not residential. But I mean, I suppose it's possible that it could be, but that's an accountant can probably best answer that.
And do a lot of these ordinances, kind of a follow-up question related to that, do a lot of these ordinances apply to, let's say, like it's not common with residential, but like a triple net lease, or where the tenant's responsible for that kind of stuff? Does it apply, or is it?
Yeah, the ordinance. So that would probably be, depending on how it's structured. It just wouldn't be a residential lease under the ordinance. That would be its own separate lease, and I think that would be strictly commercial. And in which case,
so the landlord wouldn't allow that under a residential.
Correct.
Right. I think this question that had come in, like process for leasing the property in terms of, is it best to get separate checks? I always recommend cashier's checks. You know what I mean, especially if the timing is quick. But I mean, what's best with that? Is it separate checks with memo fields for each check? Or
yeah, you mean for instance, 1 month rent and a security deposit? Yeah, it's great to do those as separate checks.
Okay.
Because they really should go in separate accounts. So for instance, the security deposit check has to go into one account, and then the rent check should go into a separate account. So yeah, it would be great for those checks to be separate. And I haven't really experienced a lot of check fraud when it comes to tenants. Most of the time, they want to, occasionally you'll hear a check bounce or something like that. But for the most part, I don't really see a need for cashier's checks or money orders. They're nice, but most of the time checks are valid, and it's very rare that I hear of tenants bouncing checks. I hear of tenants paying late, but once the check is there, it's there. You can always accept cash. You can do all sorts of things. But yeah, in terms if there's reason to believe that there might be some issues, then a cashier's check or money order is fine. But most of the time, I think if you just have two separate personal checks, you've met your requirements as a landlord.
Okay. And then the last question, and I appreciate everyone who put questions in. We're gonna be having a lot more of these events, and hopefully, I know I did. I found it well worth the time spent, and hope that everyone comes out to the next event as well. But if you can't make it to online questions, I guess is the next best option.
Yeah, this was great.
Next, I guess the last question kind of leads into some of the services. Do you ever do anything like on a transaction coordinator type basis for rental transactions? Where somebody asked if you, because some of these rules and regulations are, you got displays with their crime-free addendum and all these other different things to navigate. Is it something that you'd ever do? I don't know if you currently do or ever consider doing a.
I would do so when I do things like drafting a lease, reviewing a lease for clients, advising on these issues. It's just billed on an hourly basis, and it's billed at $250 an hour. And most of the time, it gets done within an hour or two. It's pretty rare that it goes beyond that. With commercial leases, it usually goes a little bit longer, but with something like this, I would consider it under the lease review and document preparation portion of the practice, and that would just be billed at $250 an hour. In terms of negotiating between parties, I usually don't get involved in something like that, so I wouldn't get involved unless I wouldn't interact with the tenant unless the tenant had an attorney. But I suppose it's possible. I mean, if it was something that was unique, but most of the time, I would do lease revisions and or drafting of the lease. That's something that I do pretty regularly. And then I can submit it to a tenant or to a tenant's attorney. And then reviewing the lease and consulting on something like that, that's not something I usually charge for unless it's extensive. But if you ever had any questions or anything like that, you can feel free to reach out and I can advise or at least go in a direction. And there's no fee for something like that. But when it comes to drafting the documents themselves and preparing the leases, there would be a minimal fee for the client for that.
And somebody asked, and it kind of goes to the cost perspective of evictions. Like, do you ever do evictions on a flat fee basis or?
Yeah. So evictions range. And I'll tell you, the range in Chicago. The cost for an eviction is between $1,500 to $2,500, and I charge $1,500. A lot of attorneys do. Some of them stretch into $2,500. The other costs that are associated with that include the filing fees, which is around $300, and then costs of serving the defendant. So the filing fees themselves are around $300. Sheriff service is about $60. If there are multiple defendants, it's more. And then if the sheriff can't serve those defendants, you have to pay a special process server. And the special process server runs between $100 to $150. So those are some costs that can really add into the litigation piece. But if you're looking to evict a tenant, it's going to cost around, with the filing fees and service, you should budget around $2,000 to $2,500 and expect that you're not going to get rent for 3 to 5 months. It's not a great process, but in some ways, I believe it's designed to encourage the parties to work it out.
Yeah.
And, if there is, one last thing that I can point out is that if you're looking at not getting rent for 3 to 5 months and paying $2,500 versus perhaps missing 1 month of rent and then even paying a tenant to move out if they don't have the funds to pay rent, if you're looking at that situation, let's say it's $1,200 a month and you pay another $500, even though you as the landlord feel that you're in the right, $1,700 is much better than losing 3 to 5 months and paying $2,500.
I have done that. I bought a house myself.
Mm-hmm.
When I made the offer, there was no tenants in it. When a month later I went to show my mother the exterior of it, we just happened to be in the area, I go in the back and I'm looking through the window, and there's a person looking back at me.
Oh, jeez, yeah.
So she opens the door. How can I help you? I said, I just bought this house. Who are you? She goes, I just rented this house.
Yeah,
And
yeah.
I'm like, oh my God.
Right.
So the thing that I had to do, and it was my attorney's advice, which I took, he says, give them first month's rent, but don't give it to their hand. You're an agent, find them another house. She had 4 kids and 2 dogs.
Wow.
So find them another house, pay that money, $1,700 to $2,000, to the new landlord, and tell them this is your new address. I
Yeah.
just paid for you.
Yeah,
And that's what I had to
that's
do.
valid. I mean, that's probably a lot less of a headache than you would have incurred if you tried
Right.
to evict that
Right.
person.
Yeah.
It's just the reality of it.
Right.
And some landlords don't want to hear that. Some landlords, and I deal with it frequently. I'll tell a landlord, look, well, I'm owed $2,000. Why am I going to pay somebody? Well, it's more likely that this person is going to get out and that you can move on and rent it out. Because if this person is occupying and not paying rent, there are situations too where it's important to make sure there's a judgment entered against somebody, to make sure that you garnish wages after that person leaves. There are situations where it's important to do that because it might be a serial tenant that does this. And maybe there's another reason why a tenant would want to enforce that. But most situations, if the landlord simply wants to rent out the unit as soon as possible, the money judgment is not that important.
Well, the other thing was, my question to that one is though, did I have any recourse for that seller and their agent for not disclosing to me that they did this?
Yeah, so at the closing, you would have gotten an ALTA statement, and that ALTA statement says, and the seller has to affirmatively fill in that there are no unrecorded leases. And it appears that there was an unrecorded lease here, even if it's a month-to-month lease.
Mm-hmm.
But it certainly wasn't disclosed to you.
Right.
It appears that the seller may have entered into that lease, in which case the seller now signed a document saying there are no unrecorded leases, but there were. So your damages are the costs for making that person move,
Mm-hmm.
which is a couple $1,000s. You could potentially rescind the contract. If it was a worst case scenario, let's say that seller enters into a 5-year lease at $200 a month or something like
Right.
that,
Right.
and doesn't disclose it to you. That tenant has the legal right to stay in that building for 5 years.
Yeah.
So you could rescind the contract. There's a number of different remedies for you, but again, that's an issue too. Do we want to litigate for $2,000
Right.
against the seller?
Well, the thing was
Probably
this though, I got, when I bought my house, I had Ida. That was my house that I bought.
Mm-hmm.
And I had an 8.5% interest rate when it was 11%. So I did not want to lose my Ida money.
Right.
So for me, sure, I'll give the $2,000 and get her out, And,
Right.
and I looked and I called her every day and be very nice. And she says, "Oh, you find me a house, I move."
Yeah.
It's
Well,
okay.
that's a creative way to get out of that problem. So that's good.
So it happened. So I know what it's like. Just so we reiterate what we
Yeah.
were talking about, in the city of Chicago, to get a tenant out through the process of eviction, it's going to cost anywhere between $2,000 and $2,500. It's going to take anywhere between 3 and 6 months with all the worst case scenario to actually get them out of an apartment.
I usually say 3 to 5 months, but
Okay.
yeah.
I think I'm looking at worse. Give me another 30 days.
Yeah, right, exactly. Yeah. So you're looking at
If you have a 6-unit apartment or a 12-unit apartment and you have 6 tenants that are not paying you rent, so now you got to do this 6 times.
yeah, I will say it's a very small percentage that goes to trial.
Okay.
So it's a very small percentage of landlord tenant cases that go to trial, and those cases are usually resolved prior to 3 to 5 months. It's
Okay.
just if you file the eviction, now we have a little bit of a different process. Once that eviction's filed and served, now we have somebody that's going to perhaps negotiate with another attorney or be told by an attorney that you're probably going to lose a trial and you have to pay the attorney this amount to get to trial. And, so there are all these different steps that encourage settlement along the way.
Okay.
So But that's true. I mean, it does usually result in 3 to 5 months of unpaid rent and about
Alright.
$2,500.
And also, you're exempt if you have 6 units or less and you live in one of the units, you don't have that issue with
Correct. Well, you don't. You're exempt from the ordinance,
that ordinance.
but you still. So that and the ordinance again is punitive for penalties and things like that.
Okay, got it.
But you still have to abide by the terms of your lease, for
Right,
instance.
correct.
You're not exempt from that.
Alright, well, that makes sense.
Well, I appreciate everyone. I appreciate Mike's time, and
Yeah, no
I appreciate
problem.
everyone coming out, and then also the questions online. If everyone would, if you know, put their email address if you're interested, or your phone number, you can message Mike, and we're gonna be having a lot more events like this with various other topics too. That hopefully I'd love to have your attendance, and we'll go from there. But keep you posted via text or email, and go from there. But I appreciate Mike's time, and
Okay,
I
thank
hope
you,
everyone
everybody.
has a wonderful rest of the day.
All right. Thanks, guys.
Take care.
everyone.
Thanks.
Thanks.